Now please join me in welcoming Sam Houston. Thank you very much.
Thank you, Evan.
Good to see you. Appreciate you being here. Thank you.
Thank you, Evan. I appreciate the opportunity.
Pleased to do it. You are a Democrat running down ballot in Texas in 2014.
That's right.
I think the other Sam Houston had a better go of it.
Well, we'll see.
You don't think this is enough? I mean, clearly any Democrat running for statewide office in the last 20 years has had an uphill battle, but this seems to be a particularly difficult year for Democrats given the national political environment, and in Texas, where there was hopes that this might be the year when things turn competitive, people on your side hope that. The fact is, no evidence yet that this is any more competitive an environment than in previous years.
It is, but you know, you mentioned Sam Houston, and I'll probably get the quote wrong, but I think he was the one that said, do what's right and accept the consequences, or something along those lines. And that's how I look at these races.
Yep.
You know, if you don't try, you don't succeed. And I understand it's an uphill battle, but you know what? I feel a lot of enthusiasm out there.
Yep.
There's a groundswell that's really hadn't been tried in Texas, and people talk about battleground and all the effort.
Yeah.
I think that's there, and in my race, which I want to focus on,
well,
obviously,
of course.
I have an opponent who's not here. I have an opponent who won't show.
But does it matter? You know, the fact is, it is a strategy, time-tested, that if your party is ahead, generally, and you have an R next to your name, let's say for the last 20 years, you can take a knee and run out the clock. It doesn't make a difference if Mr. Paxton doesn't do interviews with me or with editorial boards. It doesn't make a difference if Mr. Paxton doesn't appear in public between primary day or runoff day and election day in an environment like this. Would you agree?
No, I think so. I think that I think we're on the verge of it making a difference. I think in this case, in this situation, and you mentioned, I ran in 2008, got close to 46%.
It was for Democrats over the last 20 years a pretty significant percentage of the vote.
Exactly.
Right.
And in this race, the message is getting out. It's hard to raise money. I'll spot you that when you're not already an elected official. But we're getting the message out every way we can about Mr. Paxton's ethics problems, about the criminal issues, and it's an issue that was raised by his opponents in the Republican Party.
How'd that work out for Dan Branch?
Well, that was a very low turnout, far-right vote. So I don't think you can compare that to the general election where we'll have Democrats, moderates, and it'll have a much larger turnout. So the way I look at it, I'm starting out where Dan Branch spent a large amount of money informing moderate Republicans of Ken Paxton's problems, about what, $4 or $5 million.
So you believe actually Dan Branch's spending in the primary ultimately benefits you in a general, because that bit of news has already gotten out to some in his party. It sounds to me you just took the opportunity to define your campaign in the negative against Mr. Paxton as opposed to in the positive for yourself. Is your whole campaign basically Sam Houston, I'm not that guy?
No. I think it's important to know about Mr. Paxton, but again, that's why I come on these programs, and that's what I come on. I mean, my campaign is really about trust, about someone who's practiced for 26 years and bringing a private practice into the Attorney General's office and taking the politics out. That's what I want to do.
Taking the politics out of the Attorney General's office.
Absolutely. That's one of the big parts of my campaign.
Why did you decide to run? Obviously, you made a decision, as I said, in 2008 to run for state Supreme Court. Practicing attorney, probably doing okay for yourself, have a happy life, a couple of kids in Houston. You could just continue along that same path. No need to do this. No one forcing you to do it. Why decide to run?
It would be much easier to stay there. My children are teenagers. I laugh and say I'm running for statewide office, running a full-time practice, and raising 2 teenagers right now. So I could choose an easier path, but I'm running because I truly think it's the right thing. I think that politics, in particular in our state, with the Republican-dominated slate and in the Attorney General's office, has simply ended up being too extreme, too radical, too much rhetoric. I think that for our state to do better for all the citizens, and I'm sure we'll talk about that, and we'll talk about the AG's office, that if both parties are represented, if you have all the voices heard, then our state does better. Our party has been down for a number of years. But again, when you go back to say, why do you run, and people ask me that, again, to me it's imperative that we run qualified people every time, work as hard as we can, get out and get the message. And I'm an optimist, and I believe that when the message is out about not only me, but about my opponent, and that's important, but that we have better ideas, we have real ideas to talk about education, to talk about the future for all Texans.
Right.
And that when we have those ideas prevail over rhetoric and we'll win.
Yeah.
That's why I'm running.
I want to talk about those ideas. I want to ask one more question on the politics of this before we get into
Sure.
it. In some respects, running as a down-ballot candidate in a challenging environment is doubly hard.
I'll
Right?
agree.
Because you have both the negative of the party ID if the party is out of favor, and you also have no name ID, really, if you're far down the ballot. Very few people pay attention. I'm reminded of Kirk Watson's race for Attorney General in 2002
Right.
against Greg Abbott. He ran a very good race by everybody's estimation, but he basically did the same as everybody else, because if you're running for AG, people are really paying attention further up the ballot. How dependent are you on Wendy Davis's performance on Election Day to possibly snatch victory from the jaws of defeat? If she does better than expected, does that help you? But if she does worse than expected, does that sink you?
If she does better than expected, obviously that helps me.
Yeah.
If she does worse than expected, I would be disappointed. I don't know that it necessarily sinks me. But look,
You're not counting on straight ticket votes ultimately to pull you over the line.
But the better the straight ticket, the better the turnout, the better that we get. When people vote, Democrats win. When more people vote.
Yeah.
Wendy Davis, Leticia Van de Putte, the entire slate of Democrats drives that. The better everybody on the Democratic ticket does, the better that I'll do.
It ultimately pulls you up.
Right, but every race is also different, and again, I was talking about some of the differences in my race, which is why I kind of brought up my opponent.
let's get to a particular issue that relates to the AG's performance, both the last AG, the current AG, General Abbott, and whoever serves next, but through the filter of something with Senator Davis that's happened recently. Senator Davis, as you know, as anybody who's turned on a television over the last week knows, has an ad on that is ostensibly about tort reform,
right,
or ostensibly about the impact of tort reform in Texas. Her contention substantively is that pre-tort reform Texas was a more favorable environment to be a litigant if some horrible accident were to befall you as it did General Abbott, but that post-tort reform Texas, it might be hard to see the same result in terms of the settlement that he received back then and, versus today. What has become controversial is not necessarily that point, but the use of the image of the empty wheelchair in the first few seconds of that ad.
Right.
Would you have run that ad, Mr. Houston?
Well, I think it's a fair ad to say that, someone, when you're talking about his policies, I don't think Wendy Davis was attacking him because he's in a wheelchair.
Yeah.
And I'm certainly thinking that it's fair to talk about someone's policies.
Was it tactically a smart ad or politically a smart ad, the way it was executed?
That's been debated back and forth.
Right, but I'm asking you.
I mean, was it tactically smart? Again,
it's a yes or no question. I hate to be lawyerly with you, but you are running for AG.
You're being lawyerly for me.
Yeah.
I don't know the content of every ad I would run. Would I run an ad pointing out my opponent's issues and hypocrisy? Sure. The ads that I would have run now have been about Mr. Paxton, point out the things he's done that are, whether his ethical violations, his criminal issues. I think that's fair.
Tough ad is
fair.
Tough
ads are tough ads.
That's tough ad.
And would I run a tough ad against Greg Abbott if to show the hypocrisy on the settlement he got versus the rulings he had and the issues? Sure.
So do you think tort reform, to take the substantive thread of the ad and get into the issues part of this discussion, do you think that tort reform has been good for Texas or bad for Texas, generally speaking?
Well, I think there's certain parts of tort reform that we needed, but I think it went too far.
Which parts were good and which parts went too far?
There was venue when you talk about tort reform, you're talking about years. And again, there were several years of different tort reform. 2002, you go back to years of tort reform that's passed on venue provisions, different things on the civil litigation. But
I'm talking in the main about the constitutional referendum.
Sweeping changes to product liability, caps that were set, that there's no change on it. I think that's overall that's going to damage us in the long run.
Why will it damage us in the long run?
Well, because again, people need justice. And so, obviously we need reasonable justice, and we don't need runaway situations. But and when you talk about tort reform, by the way, while I'm talking about it, the Supreme Court, and this is something I ran on quite diligently whenever I ran in 2008, court-imposed tort reform has been as important as legislative tort reform.
But of course, what most people point to, Mr. Houston, when they talk about tort reform is the ability or inability or difficulty of an individual who's been harmed in some way to find justice within the system, because now in post-tort reform Texas, it's harder to get attorneys to take cases, and it's harder to be predicted. The outcomes are less predictable as they might have been in the days before the constitutional referendum. So do you think that an individual who's harmed today has an adequate opportunity to get relief in the system. That's typically the question.
In many cases, they don't.
They don't.
And that's a problem, and that's why I think in many cases tort reform went too far.
So
it's like a lot of things. It's like a lot of things that's happened, particularly in the Republican-dominated system.
Right.
You know, you perceive a problem, and instead of working towards the middle, the pendulum swings all the way to the other side. And that's what we've reached with a lot of issues. Yeah. And so that's something I talked about in the Supreme Court, and I said now is that you got court-imposed tort reform where people are, if someone is, you know, if you limit it so that it's reasonable and there's a good decision-making because of the laws, that's okay. If you make it where someone doesn't have a remedy, they can't get a lawyer, you've imposed it where the lawyers can't make a fee so they don't take it anyway, it's gone too far.
Too much. So if you're elected Attorney General on November 4th, what can you do in that office to impact this conversation? What can you personally as Attorney General do? About
tort reform? Tort reform is more a legislative judicial function.
Right.
The Attorney General's office, but one thing that I do think is important, I've talked about, Evan, is that, you know, the Attorney General's office is an office that can do great good, and one of the things that I think that the focus can be more on is consumer protection, environmental protection, because there are a lot of cases where individuals, for example, where it's a small amount, payday lenders jumps to mind, you know, lending issues, people just flat being duped by salespeople on a broad scale, where the Attorney General's office steps in, and while you don't represent individuals, you can remedy the problem and get rid of the bad business.
Nonetheless, on behalf of the state, which is a state made up of individuals, you can be an advocate for individuals.
Exactly, which in a tort reform view, where again the DTPA has been watered down a lot judicially, where, you know, lawyers don't take it as much on an individual basis. So that may be an area where the Attorney General, it's not changing tort reform, but it's helping people who've been impacted by tort reform.
Well, let me ask you to move from tort reform to more equally kind of contemporary issues. There have been a series of court rulings over the last few weeks, instances in which the state of Texas has defended positions taken by the legislature or has advocated against positions taken by the federal government on very large issues. And we've seen whether it's voter ID, gay marriage, abortion, school finance. You know, Texas and the courts has been kind of a big thing over you turn around every 5 minutes, there's another big story, some other big. So I want to ask you about these, not exactly a game show speed round. I don't want you to just kind of go yes, no, but I do think let's kind of try to go through them quickly. So the most recent of these, of course, is the decision by the Roberts Court to allow abortion clinics to remain open.
To not impose
the impact of the abortion bill. Somewhat of a surprise. This is the Roberts Court that decided to do this on a ruling of 6-3. Again, you're the Attorney General. You know, you are personally pro-choice. You are running a campaign that is personally pro-choice. So you become the Attorney General of the state of Texas. The legislature has passed this bill. You represent, as you say, the state. What do you do as Attorney General in a case like this?
Let me preface it again. I'll answer your question. But let me preface it by it's a difficult question on all of these. And when I'm elected Attorney General, I mean, I'll take into a role that causes me great consternation on a number of issues because obviously there may be your feelings you have as an individual about whether you're pro-choice, but you do have an obligation to defend the state. And this has obviously been a source on the school finance lawsuit, which we can talk about. But my look at it, and I've studied it and looked at the role, read the Constitution, and thought about it. And you know, every Attorney General, really, from each one, if you study from John Hill, Maddox, all of them, everybody does it a little differently. But I would take my role very seriously. First of all, that I would, if the state sued, that it's important to defend the state. But my advice might be a little different on how you could resolve it, how you could do.
But you acknowledge that as Attorney General, you acknowledge as Attorney General, you would not be in a position to, would not be appropriate to put your own personal point of view ahead of the obligations of your office.
There's not. So you know, there's a difference, though. Of course, if you think that the legislation's unconstitutional on its face. You know, if the and I'm not talking about this particular lawsuit, but the legislature.
Do you believe the abortion bill is constitutional?
I think there's significant problems with its application, particularly as the judge had ruled, the district court judge ruled, because you know, overall, I would be worried about placing any arbitrary limits on a right. There's parts that may be constitutional. There's parts that's not. And so my advice would be, again, Evan, it wouldn't be what I thought, though, because what I think is not important what's important to a lot of people. But,
Right.
but my advice would be, what do you think the court's going to do to the state? And it might be, what is the more reasonable thing to do as opposed to spending money and taking that chance? So, you know, again, the problem I would have, and again, I take this seriously when I think about it, I would not want to be in a position where just because to impose my will. So on the abortion thing, abortion case, people have asked, what would you do? And you know, despite what I think about it, particularly at the progress,
Right.
that's gone through trial and it's in the courts of appeals, that needs to play out and see what the courts
So,
do.
so the fact is, Mr. Houston, materially, your response to what happened on Friday with the abortion legislation, your response, or whatever day it was, earlier this week, your response would be materially no different than Mr. Paxton, should Mr. Paxton be.
No, that's not true.
Well, then tell me how it would be different, because you'd both be Attorney General, you'd both have the state as your client, you both would not be in a position to put your personal view of the issue ahead of your responsibilities of the office.
Right.
So how would it be different?
Well, it'd be different, particularly, you know, the tenor and the way that the office defends matters and the advice you give to the legislature would be different.
What, are you going to throw the fight?
No, I would not throw the fight. No, I mean, that's easy. I would never, ever take it. But, you know, the way you advise the legislature initially would be different. The way that you advise the legislature on how to proceed would be different. The statements you made about the matter would be different. So would my office defend the bill? And again, it would be, you know, people, the appellate lawyers defending it. Would that be different than Paxton? I think so. Would we still defend the state or at least continue the appeals? Yes. So I think the way it would be handled, again, would be different, and you're talking about a different degree and tone. I mean, and I understand your question,
I guess, Mr. Houston, I don't buy your argument.
Okay,
I mean, the fact is, either you're the Attorney General of the state of Texas or you're not. And the law wouldn't be different if you were in a job or Mr. Paxton were in a job. The only thing that would be different is that you're pro-choice and he's pro-life.
Well,
so materially, I'm still struggling to understand how it would be different.
Well, it'd be different in several ways, because again, you go back to not only this, you're talking about this particular case.
Well, let's go to school finance. So in the case of school
that'd be
finance, you've got more than 600 school districts that have sued the state, thus far successfully.
Right.
Judge Dietz has said, we find that the state is out of compliance with the constitutional obligations to fund schools in an adequate and equitable way and all that kind of stuff. And the state has elected to pursue this to the Supreme Court to appeal the ruling. Are you saying that if you were the Attorney General of the state of Texas that you would decline to appeal because you personally side with the schools? Or would you continue to defend the state the same way that General Abbott has and that presumably Attorney General Paxton, if he were elected, would?
Well, a very different approach that I would take to that, and I've already said this on several occasions, and again, it depends on the stage of it as you go forward, but I think that really an effort ought to be made to try to resolve that without just waiting for the Supreme Court to rule. Again, the Attorney General, if you decline to appeal, that's not necessarily going to bind the state, because other people, that's been in the past. So I would work towards use the bully pulpit, because that's where, again, there's degrees of difference in ways Attorney Generals. When you say, how would you and Mr. Paxton be different? You use the bully pulpit part of it, you defend the state, but obviously when I'm a lawyer, what I say to my clients influences eventually their decision making. So particularly with school finance, I think there'd be a difference between, you know, I'm the Attorney General, I have to defend whatever you do, versus I'm the Attorney General, I'm a public official, I'm concerned about the Texas Constitution, which requires, you know, adequate education. I'm concerned about property tax issues. Here's Judge Dietz's ruling. It's a roadmap. We've got 2/3 of the school districts that are suing right now, so 2/3 of the state is unhappy. Let's call this into session and figure out a creative way, bring in people, bring out a creative way to end this and not just wait and see what the Supreme Court does. And, you know, I think that would be a very different approach that I would take.
And if the governor and the lieutenant governor and the speaker and other statewide elected officials disagreed with you and believed that you should pursue this case to the absolute end of the legal system, you would still be in a position as lone wolf Attorney General to not go to the Supreme Court and appeal this?
I mean, you know, then you're talking about a hypothetical. To me, that would
well,
be
actually,
surprising.
if you get elected Attorney General, the situation I described to you is not a hypothetical.
Maybe not. I mean, well, you know, you say that, and I think that's been an assumption, but I've sat and listened to the debates. I've heard every single person say, we need to improve education. Right. Every person say, we need to find a better way. So I'm not sure it's it's just an assumption you can make that whoever the governor is however the state works out that, particularly if you've got an attorney general who's using the bully pulpit to say we need to take care of this, that you wouldn't get.
So that would be, in the end, that would be your position. It would be to try to figure out some way
Absolutely.
to persuade people rather
look,
than pursuing the legal remedy here. Let's get this thing settled.
Evan, you just basically summarized really the difference that I would have against, certainly against Senator Paxton, and the difference that I have with General Abbott. Look, I get it. You're the Attorney General. Whatever you think, you have to defend the state. But it's your advice that you give in doing that. Yeah. I would work a lot more instead of spending millions of dollars in tax money on all this litigation, whether, we're talking about all the different things you want to talk about, to work towards trying to get some solution. I think too often the Attorney General's office, in siding completely with the Republican Party and some of this legislation, you forget that other people are affected in a negative way. So, would I ever abandon the state? No, I don't want that. I don't want to come around here from saying that I'm going to be this renegade Attorney General that steps in there and, and even though, and because I disagree with certain litigation, that I just say, we're not going to do this anymore. I don't think I could do that. Yeah. But will I work towards using my powers of persuasion, and some have said I'm pretty persuasive, would I use that to try to convince people to do the right thing? Yes. And I think that's a difference in the way that General Abbott's run the office lately, and it's certainly a difference, well, we guess, from the way Senator Paxton would. Right.
General Abbott has actually said, I would go so far as to say boasted, that his job these days is to come into work every day, sue the federal government, and then go home. Right. He said this himself.
He did.
The fact is, he doesn't see that as a Republican versus Democrat thing. He sees that as a Texas versus the federal government thing. So do you not feel that Texas has an appropriate reason to push back against the encroachment of the federal government on some of these issues? Because obviously on some matters related to redistricting and the Voting Rights Act, on the EPA, which has been, I think, of all the lawsuits that the state has filed over
that was the majority.
As the majority have been against the EPA. Do you not believe that the state has cause to want to push back against the federal government on some of these issues?
Well, two ways. First of all, there may be times when you disagree with the federal government. Now, the EPA lawsuits, again, that's the state pushed back, but I think in the end we spent a lot of money and there was a lot of blowback on that and it didn't work out. But I think that there's too much rhetoric in it. I mean, all of a sudden, when you've got a Democratic president, there's 2 lawsuits versus 26. And I think that...
So you think in the end it is about party?
Probably. Yeah. Yeah, I do. I think it's politics. It's exactly what's wrong. And it's not only that, it's always just this, again, there may be times when you have a disagreement, but it's what I just said about school finance. Right. I bet there's better ways to work out issues with the EPA than immediately issuing a press release saying we're going to suing, bragging, I've sued the Obama administration 26 times. I bet there's a better way to do it. And sounds like a campaign slogan, but it's true. Lawsuits ought to be the very last resort when you've got government suing government. There's better ways to do it. It ought to be a last resort, and it definitely should never, ever, ever be a campaign slogan.
So as Attorney General, had you been Attorney General in the last few years, you would not have sued the EPA the way that Greg Abbott did?
Probably not.
And would not going forward?
Probably not. I've certainly tried to work things out. And when you go forward again, because a lot of these lawsuits, again, when you look at them, individual litigants can bring these, and that's a lot of it's done. And so the state's entering into an area where if there's someone who thinks they're regulated or they can't be regulated a certain way, these companies bring these lawsuits. So how often are these done just for, it's kind of, again, it's a 10th Amendment grandstanding versus the courts really ought to be, private litigants in that situation. Government suing government ought to be pretty rare to me.
What about gay marriage? So this is obviously an issue that is controversial. It's a little bit like abortion. It's hard to solve politically. People on both sides feel strongly about their position on it. There's been some evolution on gay marriage, polls would suggest over the years. But the fact is it's still an issue that divides communities and divides people across the country. So what do you do on that? I mean, you have a situation where the state is in the minority now based on you look around the number of states in the country, Texas is in the minority of states in continuing to seek to ban.
And the number of the courts have struck down bans everywhere else, and I think ours is in the 5th Circuit
So again, as Attorney General, your position on this issue is
Well, I mean, personally, I think I'm against the gay marriage constitutional amendment. Yeah. I think that I think that people should have the right to choose who they marry, and the government shouldn't be intervening in that particular issue. I also think that it's eventually going to be held unconstitutional. by the United States Supreme. And that's not my opinion.
Right.
That's pretty much looking at what the Supreme Court, testing the waters. So I would
Well, the decision that they made, the Supreme Court made a couple of weeks ago, declining to take the baton, right, from the lower courts would indicate. But nonetheless, the position of the state legislatively, and at least as the voters of the state have been heard thus far, is not where much of the rest of the country is.
That's right. And
so you're the attorney for the state.
Number one,
what do you do?
Number one is, well, right now that is already in, the appellate stage is already in the Fifth Circuit. I don't know what would happen eventually when I take where that would be, whether there would be a ruling, whether that would be in the Supreme Court. What I've said before is that particularly the same with all of the other legislation that's been tried, or that's so far along, I don't think it'd be my place to immediately, we're going to yank the appeal. I'm just not going to come across and say that, despite my opinion.
So if things are proceeding through the appellate system that you personally don't agree with, or that had it been your decision to bring those actions you might not have brought, you would not enter the office and say, we're going to call everything to a halt.
No, I would not do that. Yeah. I mean, I would think, but I think I would, again, when I was talking about using the bully pulpit, I would urge the legislation, and I would urge that instead of spending money, that maybe we rethink that. And then again, one thing about what I've heard the rhetoric on the Republican side about that, and also as far as raising arguments, I would make sure that my office raised only any potentially legitimate arguments, because that's some of the things that have been raised about procreate, about children. You'd have to handle it carefully, and but I would urge quite a bit that let's not spend more money on this. The issue's there. Let the United States Supreme Court eventually decide. Yeah. And that's probably up to their role, not me. But when you talk about the majority of Texans voted and all of this, well, that was a very low turnout amendment, if you remember that. So
yeah, but so what?
Well,
every election in Texas is low turnout.
But don't make the rhetoric out when you defend it and say the majority of Texans are in favor of this.
Mr. Houston, the fact is, when people don't choose to vote, they forfeit their right to complain about the outcome of elections. This has been ever thus; it will be ever thus. How can you say that it's illegitimate because it was a low turnout election?
I didn't say it was illegitimate. I said the rhetoric shouldn't be that the majority of Texans are in favor of this ban. I said that was a low turnout a long time ago.
Well, maybe a majority of Texans who cared enough to vote
at that point. But I think that's changed a lot. I think there's been a change, as you said, in the mood in the nation. And I think eventually the United States Supreme Court or a court is probably going to hold that our amendment is unconstitutional.
If we put that referendum on the ballot today, given the fact that things have evolved, right, do you think that Texans would vote the same way that they did the last time?
I would hope not. I mean, I'm not a pollster. I'm a lawyer. But
and if Texans voted the same way as they did the last time, would you, as Attorney General, feel obligated to honor the wishes of the voters and proceed in defending the law as it exists on the books?
Again, if the Texas voters voted that in the voting out, my job as Attorney General would be to defend it. The way I defended it and the arguments we made might be different than the Republicans.
In other words, similar to school finance or similar to
the way I handled
the abortion bill, it would be a difference in tone, tenor, and approach as opposed to the way you read the law.
Right. I mean, right.
Let me move to an issue that has also come up in the governor's race, and that is the Attorney General's role as an honest broker in examining the contracts related to the Texas the Enterprise Fund. This was an issue that came up particularly in the second gubernatorial debate. It was after the revelation of the state audit and the degree to which companies had or had not honored promises to create jobs, and whether or not there were in fact agreements with companies that had received, entities that had received funds from the Enterprise Fund. What did Greg Abbott do wrong in that case, and what would you do differently if you were Attorney General?
Well, there was really two issues. There's oversight, and then of course there's the open records decisions. The bigger, and again, a lot of the oversight had to do, and it was a little more nuanced about the Attorney General's role along with the comptroller in reviewing in the funds expended versus the governor's office. The bigger issue I had with that, particularly Enterprise Fund and the Attorney General's office, had to do with the rulings on the open records request made, I think it was by the Dallas Morning News.
So the Dallas Morning News requested to see applications that the Attorney General's office declined to provide, and it turned out that in some cases, as it's been alleged, those things didn't exist. Is that right?
Right. Yeah. And that goes into a whole other issue about the Attorney General's office, which I think ought to be stressed, and it's in this particular form. I bet we would stress it. And is the Public Information Act and the Attorney General's role in basically enforcing that act, which is important. And my disappointment in those rulings was, obviously you can go through, is that I think particularly here towards the end, there's been too many exceptions found by the Attorney General's office to the public information.
To what should and should not be.
Right, and they're read very broadly,
Right.
both on the chemicals and in the
Well,
enterprise fund.
we'll come to West in a second. This Attorney General and his office contends that they've been quite faithful to the spirit and the letter of open records over the years, that they consider themselves to be one of the most transparent Attorney General's offices in the history of the state of Texas. That has been part of the Abbott brand, or at least as the Abbott brand has been self-promoted.
Sure.
You agree?
Well, particularly lately, there's been a number of issues. We can raise three up, and there's two problems with what they're saying here. And there's two things that need to be looked at. One, that you can criticize what's happened, and two is to say, can we improve where it's at? What I've heard and what I think is, and I'll start with two first.
Sure.
One of the problems is not necessarily the rulings, but the delay in getting a ruling. In other words, too often are there local governments that are waiting 10 days.
Right.
Then they say, let's get an Attorney General ruling, and it's something that probably should have been produced immediately.
Right. Of course,
And
they're just working within the rules of the game.
Right, and so that needs to change.
So you need to change the rules of
Right,
the game.
that's what I'm saying. So I'm
Yeah.
saying you can improve, or not necessarily changing, improve it, because we need to take a hard look at why are they doing that. Is it because they don't understand the rules, so we need to better educate and provide better education? Because there may be that local governments are just afraid of making a mistake and releasing something that they shouldn't, and then so they get the Attorney General, and that's bad use of reporters' time. That's bad use of the Attorney General's time.
Well, on behalf of every reporter in the Capitol, thank you for being concerned about our time.
But
Doesn't happen very often.
Well, but look, your story's out, and it's important to get the story out. So so if you're entitled to the records, and if you're a private citizen, certainly shouldn't be where in the days of PDFs and electronics that there's an exorbitant cost associated. So we need to take a good hard look at how that's done and what the Attorney General's office can do to educate, enforce to the extent we can under the Public Information Act.
So be more active and passive in being an advocate for open records.
Convene a group of lawyers and people and say, what can we do better under the Act? Do we need legislation to enforce the Act?
Right.
That's number one, because I think that would make a big difference. Again, maybe not a headline difference,
Yeah.
but a day-to-day difference, which is what one of the hallmarks, I think, of what I want to do as the Attorney General. Now, when you talk about the headline difference, the more apparent acts, the disappointment, and you talk about with West, is the approach to some of these big cases. After West, after this chemical explosion, people asked for the location, the documents, the hazmat documents that would show the location of these dangerous chemicals. Been provided for years. There's two statutes that basically require, a federal and a state statute that would require that.
Yeah.
But then in that opinion, the Attorney General found a very kind of broad exception under the Homeland Security Act, which I think goes against kind of the tenor of the Public Information Act, is it needs to be a very specific exception.
So you would put public information ahead of Homeland Security in the case?
No, I would put, no, not at all, because the Homeland Security issue was a very broad, that could apply to anything. If you want to say that, if you want to start talking about you'd put Homeland Security above, well, you can apply that to anything. You can use the Homeland Security Act to erode First Amendment rights, open records rights, and you could always say, well, I'm worried about a bomb, I'm worried about that. Well, you got to nuance it more. And when you have state statutes specifically saying, give out the information, and when you have the Attorney General himself saying, well, people can drive around and get it themselves, well, you're not too worried about that. So what happened was you had you had the Attorney General say, well, I really wasn't aware it was a letter ruling. Right. So all of that to me adds up to a lack of communication in open records, a bad result that people criticized, a kind of absurd result. You can drive around and get it yourself, but they don't have to give it to you.
So Attorney General Houston would have released those documents when asked?
Sure.
Simple.
Sure.
We have a couple minutes before we open it up for questions. I was adamant, in fact, about not turning this into the fun time whack at the Ken Paxton
well, you haven't done that,
variety
so
hour.
I've noticed that.
But I do feel obligated, since your campaign in part is based on disqualifying your opponent, I do feel obligated to ask you why you believe he is not fit to serve.
Sure.
The fact is, he's paid his fine, acknowledged that he had issues with the State Securities Board. He's refiled his personal financial disclosure forms where information was left out. I think he's described that as an administrative error or some such. Do you not have forgiveness in your heart, Mr. Houston? What exactly has he done that disqualifies him to be Attorney General?
Well, I mean, obviously you have forgiveness in your heart, but I'm not talking about that. I think you add everything together. Nobody's perfect. Everybody that runs for office, nobody's perfect. But look, here's my problem with Ken Paxton. And it's the same thing that Dan Branch said, pretty much what Barry Smitherman said. It's uniform. You know, you had a history of ethical violations starting back, and there was an article in the Texas Tribune. I read that article about WatchGuard video, you know, where it's self-dealing with his own companies. Then he doesn't disclose all these nonprofits. You have an issue where he, on numerous occasions, solicits clients for an investment advisor, takes a fee, doesn't tell the clients he's taking the fee. It's not even a written agreement that he gets the fee. We know that that's a felony because he voted while he was on the legislature to make that a felony, those particular acts. We know that he didn't disclose to the Texas Ethics Commission that he was getting these fees. I read that in the Texas Tribune. You know, again, and does it disqualify him? If he is elected and he is convicted of a felony, he is disqualified. But does it make, but I'm not talking about that, does it make me a better candidate who...
But he's only, let me stop for a second. He's only disqualified if he's convicted as a felony. You understand if he's disbarred...
He's not, that's an
Well,
irony,
you know, God bless the state of Texas, where
Right.
you don't have to be an attorney to be Attorney General, right?
Right.
So not being a lawyer would not be itself an issue, correct?
Yeah, that's interesting, yeah.
Right, yeah. You know...
But that goes way back
But
to when
you
people,
cite Mr. Branch and Mr. Smitherman raising
They did.
those issues. Do you think Mr. Branch and Mr. Smitherman are voting for you? They're going to vote for Mr. Paxton.
I don't know what they're going to vote for, who they're going to vote for. You know, there was an article the other day where some Republicans are saying they're not going to vote at all. I don't know what they're going to do, but it doesn't matter what they're going to do. What matters to the voters should be this. He did violate the securities laws. He won't talk about it. He won't answer it. He won't debate me. He won't come here and talk about it with you. You know, he won't defend himself. And what I've always said, more important than the Houston Chronicle said, it's not the crime, it's the cover-up the other day in their endorsement of me. You know, more important really, if you look at this race and how he's run this race, he won't answer the questions. If he won't defend himself, really, what kind of attorney general do you think he is? Either number one, he gets indicted and he's disqualified because he's admitted basically violating a felony, or number two, he doesn't get indicted. And here you got the attorney general who's admitted basically to a felony, and nothing happens to him because he's a public official. You know, heads we lose, tails we lose. I think that's not the type of person who should be enforcing our laws of the state, doing these important talk about it. It's hard. It's a hard deal. But if he won't talk about it, I think particularly that's very important. He's not going to be the transparent attorney general we need. That's my pitch on it, and I think it's fair to bring up. I think it's fair to talk about, and then now we can talk about me some more.
All right. Well, let's see if the people in the room here want to talk about you some more.
I may have wished I hadn't said that.
No. Well, you know what? I wish I hadn't said things all the time. It gets better.
Right.
Let's open it up to questions. We have, Agnes has a microphone. We'll walk the microphone around and use the balance of our time for questions from the audience. Sir.
Thanks for coming this morning. Just so real quick, we've kind of talked about and heard kind of things that you believe in and what you would do in the office, but what would be your priorities, your top 2 or 3 priorities as Attorney General in the state?
Good question. You walk in on day one, you got a list of things you want to do. What are 1, 2, and 3?
Well, day one, and again, I was interviewed by the Texas lawyer the other day, and it was a very good interview about, you know, the angst amongst the current, you know, assistants and what would happen. Number one, you sit down with everybody that's there. You get a list of what people think is done correctly and what's not done correctly. And now I'm not talking about the headline stuff. I'm talking about the kind of, you know, because again, it's a huge agency.
Right.
And so much of the stuff that we may not even be talking about or I don't realize that there's a problem with. Right. And you find out, is there a priority? Are there way too few people in the tort defense division? How many people do we need? So number one is you just work on the day-to-day things. What do we need to do to improve the website? So not the headline grabbing things is day number one. Who needs to stay and who wants to stay,
right,
and who doesn't? I think you got to do that, number one. It would be a change of an agency that's been in the hands of one individual for 12 years. I would hope you'd sit down with Mr. Abbott, whether he is or is not the governor, and work, right, and work out a transition, because I would hope we'd be able to work out a smooth transition. That's always very important in government, and I would work towards that end. Number two, again, when I said the issues, and it would depend partially on where the litigation is, but start working on trying to figure out some way to end the school finance. I mean, I think that's, and the reason I say that is I've listened to every debate. Everybody seems to agree we need to do better on that. But we're waiting around for an opinion. That just seems like we shouldn't be doing that, and that there ought to be a better way to get the parties together. And it's not that I'm going to be a big mediator, but work as the Attorney General with the bully pulpit to try to see if we can get some resolution and get a special session and try to get this fixed. Number 3 is, and what I've always said
But
is...
let me stop you. Greg Abbott is the Attorney General who has pursued action against this Judge Dietz ruling. Presumably, if he is elected governor, it is his and his call alone to decide on a special session, right? Attorney General can't call a special session.
No, he can't.
So how do you get him to, he doesn't seem likely, I'm just guessing now, based on his current behavior.
We said that a while ago. When I listened to what he said, he may very well, that may give him the opportunity. He may take the role of Attorney General different than governor.
So you're actually hopeful that as governor, if he were to be elected,
if he were to be elected, depending on who the governor is.
But if he were to be elected, your position is that you think Greg Abbott might call a special session rather than see this thing through to the Supreme Court?
I would hope. Obviously anybody that knows, somebody raised a great question to me, Evan, and I'm always free to think, well, I'll rethink things. I think that a good lawyer is open to rethinking things and not being, somebody may accuse, well, you're wishy-washy, whatever.
Right.
A good lawyer, is rethinks and listens. And, somebody raised a good point, well, why not let the Supreme Court just rule and use that as kind of the pulpit? And the problem with that is that's kind of what we've done for a long time, and we've ended up in, years and years of that. And you never know how the court's going to rule. The court could rule for another trial.
Well, the fact is,
it could delay things further.
The fact is, how the Roberts Court just ruled on both gay marriage and abortion would suggest the best evidence that you never know how the coururt's going to rule.
Right. Well, and this is, and believe me, that's the U.S. Supreme Court. We're talking about the Texas Supreme Court. So yeah. So anyway, but that would be a number 2. A thing that I've always wanted to look at the end of this, that I want to try to improve, and we talked about is consumer protection, environmental protection, and end this up back where I think as the Attorney General's office, it was called the people's lawyer. Different people have said things, and I don't want to be the people's lawyer. Not using that moniker, well, it's not bad. But I want it to be an office where we, at the end of the day, if I'm Attorney General for 4 years, however long I'm the Attorney General, and however many years that you would be the Attorney General, I would hope that at the end of the day, I would say that what I did is I improved the Consumer Protection Division, helped thousands of people. I don't want it to be that I sued the federal government 20 times, and that's important. It would be kind of the third thing I'd want to take a hard look at.
Good. Mr. Nichols, we're going to come over in a second here. Oh, okay, ma'am, and then go there. Yes.
I wanted to raise an issue about the tactics the current Attorney General's office is using and what you think about it. And 2 examples. In the HB2 litigation, the Solicitor General's office was caught using a coach to, in essence, ghostwrite some expert reports, which Yackel called out in his opinion and described it as disturbing. And secondly, filing the last-minute recusal motion against Judge Dietz under seal, which apparently was bunk, as the judge brought in to rule on that recusal motion, found in declining it. Are those the kind of tactics the state's attorney's office should be using or allowing his lawyers to implement?
Well, different. Every case is different, and again, when you talk about the one I'd like to talk about again, one of the things I disagreed with was the recusal motion on Judge Dietz. Again, if anything, you want that to move forward, whether you're defending it or not. Move forward and get a decision. So I thought the gamesmanship on that case I disagreed with.
Isn't gamesmanship only bad when it's done by the side that you don't agree with? The fact is, Mr. Houston, lawyers have been practicing gamesmanship of that sort, working the rules as they exist,
right,
in favor of their side forever.
Well, and then a private case, I don't like gamesmanship when I'm in private cases. But when you're talking about
even on behalf of your own client,
right? I don't like it. I don't think it always. We do it, but delay is not a good thing in any litigation. Okay. But really, I don't agree with delaying it when you're talking about public education and school funds. There's no place for that in that situation. So I would really disagree with any kind of gamesmanship when you're talking about taking the role. Again, you have the role to defend the state, but there shouldn't be any gamesmanship or partisanship. You need to make sure that the arguments you're making are fair. Because, and again, Evan, it goes back to this. When you talk about defending the state, that's a big body of interest, and there's competing interests. They might not always be the same voice, so you need to make sure you're trying to be, as much as you can, fair to everybody. That's part of your role that you take as the attorney for the state, but also a public official.
So if you were the Attorney General and you had believed that there was cause for Judge Dietz to be recused, you would, on principle, opposed to gamesmanship, as you have expressed, not have filed it?
Well, I think that you would take I think, number one, I think there was a lot of gamesmanship and delay on that. But on principle, I would never go with gamesmanship, period, on principle. And if I thought that there was cause for him to be, if there was real cause, you know, maybe you would take a different approach, but I don't know that that was the case here. I would not have delayed that particularly important lawsuit, because whether you think it ought to be settled or go
Right.
forward, you know what? It needs to end. So that would have been a very,
That would have been the argument.
that would have been a very reticent, I'd have been,
Sir?
I'm sorry. Yes, sir.
Yes, sir. Mr. Abbott has been very proud of his position in opposing expansion of Medicare into Texas and thereby denying Texas access to an awful lot of federal money for that. Should he be elected governor and you attorney general, would you be able to effect a change of position for the state?
The fact is, it's not the Attorney General's
you
call,
would.
right?
That's not the call. Yeah,
Wasn't
and I
his,
would- yeah.
wasn't really his call, wouldn't necessarily be your call.
Right, yeah. I mean, and we'd get into all the Medicaid, it's the Medicaid expansion, and it's funny because people come up and you go the role of the Attorney General and they say, you need to sue the state to get them to, you know, that's not, you know, the Attorney General doesn't sue the state. So,
Attorney General is the state.
So, no, and I could, you know, we could argue about when the Attorney General would or wouldn't decline to sue for the state, but I could say, as the Attorney General, I wouldn't sue the state. That would be, I'd give you a direct question, an answer on that.
Yeah, so to Mr. Nichols' question, you're not in a position
Yeah.
to do anything if you disagreed with the position of the governor or any other state official on Medicaid expansion. You could not jimmy it some way out of the AG's office to change that outcome.
If we started talking about that, we'd go down to all kind of permutations and rabbit trails, but I think in general what you say is true.
Okay. Other questions for Mr. Houston before we let you all go back to the world? Okay, we'll take this one, and how about be this the last one? Sir?
How would you protect consumers from practices like predatory lending in Texas?
That's easy.
As
you
a
know.
practical matter, what do you do?
Yeah, I mean, first of all, you beef up the division so that you have the investigators, the lawyers, and you're looking for things. You make sure, and again, one of the things that General Abbott did, there was the memo, you know, that basically gave him a roadmap according to many people, but you don't do things like that. And you follow the laws, you lobby for laws that make it harder with the legislature, and you follow the laws that are there, and you make absolutely certain if they violate the laws in any way, you consider consumer actions and shut it down. So you make it hard on them, you stick it to them, and you do everything you can to prevent that. And you have the investigators and the money put in there to find it and root it out where it happens.
Good. Mr. Houston, you got a couple weeks left. Good luck.
Thank you for having me.
We'll see what happens, and if you are elected, you'll come back.
Absolutely.
Okay, good. Sam Houston, thanks very much.
Thank you, Evan.
I appreciate it. Thank you very much.